quite wrong. My understanding is the Ashcroft Alliance was urging this alleged misbehavior on the part of Justice Awich as a basis for seeking his removal as a judge of the Court of Appeal. But the alleged misbehavior was, according to them, something that occurred while he was a judge of the Supreme Court. I don't see how on earth you can say, when you were a judge of the Supreme Court, you misbehaved, and that is a ground for removing you as a judge of the Court of Appeal. You would have to urge that as a judge of the Court of Appeal, there is misbehavior. Otherwise, it's illogical, it's absurd.
But doesn't it
I haven't read Justice Abel, I'm not sure how you pronounce his name. I haven't read his judgment, but I certainly know that my understanding of the facts obliges me to say that that is a wrong-headed decision.
Sir, but doesn't it speak to the pattern of behavior, if indeed it is proven that there has been misbehavior while as a Supreme Court judge, that it could transfer on to him being a Court of Appeal?
That's not to remove a judge for misbehavior. You have to allege that there is misbehavior with respect to his tenure as a judge of that particular court. So you ask me the question, I would ask you back. Isn't it illogical to say that you can remove a man for wrongdoing in the performance of his office as a judge of the Court of Appeal when you allege that the wrongdoing took place when he was a judge of the Supreme Court?
Sir, could it have implications for the decisions that he made during his tenure as Justice of the Supreme Court, particularly those in relation to the government of Belize and the nationalizations?
I don't see how, because there is no question of removing him as a judge of the Court of the Supreme Court. He has demitted office. And the argument isn't that he should have been removed as a judge of the Supreme Court. They're arguing about his tenure now as a justice of appeal. So I think they're utterly confused. I believe that when they sought to challenge the court's decision, the Court of Appeal's decision, supporting Justice Awich's position that he would not recuse himself, as the Ashcroft Alliance had asked. And when they went to CCJ and tried to get that heard, CCJ said, no, you can bring that up as part of your appeal. But during the back and forth, CCJ said, are you questioning the instrument of appointment or the manner of the justice's appointment to the Court of Appeal? And they had to say, no, that is not for the Judicial and Legal Services Commission. That is for the Prime Minister. They perhaps ought to have directed their fire at my appointment and tried to see whether there was anything on the face of it that was not properly